7th of 2025 to order, and I'll ask the secretary to call the roll call.
Leetta Sampson. Anthony Conley.
Here.
John Narkeby.
Here.
Rena Tiger. Anastasia Pittman. Terry Edwards. Ida Gonzalez. Nancy Fixico.
Here.
Leon Petit.
Here.
David Narkemy.
Here.
Joseph Billy.
Here.
Dolores Harjo.
Here.
Karen Fulbright. Ann Borba. Stephanie Lambert.
Here.
Sina Yeslith.
Here.
Lottie Cootie.
Here.
Marilyn Moore.
Here.
Henson Lena.
Here.
Richmond Larney.
Here.
Wayne Shaw.
Here.
Tiffany Thunder.
Here.
Captain McCoy.
Here.
Charlie Hill.
Here.
Tommy Chupko. Danita Harjo.
Here.
Willis Dethridge.
Here.
Desiree Emerton. I have 19 present and 9 absent.
With a count of 19 present and 9 absent, I declare that a quorum has been established, and I'm going to ask Representative John Narkemy to lead us in prayer this first council meeting of 2025.
Heavenly Father, we'd like to thank you for bringing us this far through the year of 2024 and into the new year of 2025. And I'd like to thank you for bringing us all here tonight to discuss the business of the Seminole Nation and to try to make some decisions that will advance and benefit our nation. We'd like to offer our blessings to everyone that could use a kind word here and there. And we'd like to say thank you for all the blessings that you bestow upon each and every one of us. In the name of your Son, I pray. Amen.
Amen. We have the reading of the minutes of November 9th, 2024, and the quarterly meeting of December 7th, 2024. What is the desire of the council? Representative Narkemy?
I make a motion to accept those minutes.
And then we have Representative Dethridge. Is that to forego the reading of the minutes and just accept them as written?
Yes.
Okay,
Both of those.
okay. Okay, there's been a motion made and a second. That's to accept the minutes as they are written for November 9th, 2024, and December 7th, 2024. Secretary, call the roll.
Leetta Sampson. Anthony Conley. John Narkemy.
Yes.
Rena Tiger. Ida Gonzalez. Nancy Fixico.
Yes.
Leon Petit.
Yes.
David Narkemy.
Yes.
Joseph Billy.
Yes.
Dolores Harjo.
Yes.
Karen Fulbright. Ann Borba.
Yes.
Stephanie Lambert.
Yes.
Sina Yeslith.
Yes.
Lottie Cootie.
Yes.
Marilyn Moore.
Yes.
Henson Lena.
Yes.
Richmond Larney.
Yes.
Tiffany Thunder.
Yes.
Wayne Shaw.
Yeah.
Catherine McCoy.
Yes.
Charlie Hill.
Yes.
Tommy Chupko. Danita Harjo.
Yes.
Willis Dethridge.
Yes.
Desiree Emerton. I have 20 yeses, 0 noes, 0 abstain.
With a count of 20 yes, 0 no, and 0 abstentions, I declare that the reading of the minutes of November 9th, 2024 and December 7th, 2024 have been approved. Unfinished business, there is none at this time. Reports of committees, none at this time. New business, tribal ordinance 2025-01. Tribal ordinance 2025-01. A tribal ordinance of the Seminole Nation of Oklahoma amending Chapter 3 of Title 10 of the Seminole Nation Code of Laws. Entertain a motion to approve. Motion approved by Representative Lambert. I saw Representative Dethers' hand second. Discussion on tribal ordinance 2025-01. Representative Dethridge.
Chair, I've got a couple of questions. If this tribal ordinance is approved this evening, will there be a need for, and I don't even know how much background checks cost. Will there be an increase for filing fees for chief, assistant chief, general counsel? And will the days that I think right now they got 5 days to do these background checks? If we're asking for 5 or 6 more different background checks, well, that's got to lengthen the time. So my question again would be, is there going to be a fee, and would there, all of these offices, would they be raised like for $50 each or something, or how are we going to do that?
Most places that do the background checks, and most of this will be with tribal courts that are not utilized outside tribal courts where people have lived in those jurisdictions. So it would be up to what their codes say within those tribal jurisdictions. What we would and could do, if indeed we see an influx of additional funds needed for this purpose, if it was to pass tonight, then we always have an opportunity to be able to modify the existing election board budget, which they do have a modification that could come up if that was needed. So,
basically, we'll see this year, and if we determine that there needs to be an increase, we'll do that for the next election.
Yes, and internally, you can do modifications under a tribal code as long as it's within a certain amount of percentage and don't deal with wages or salaries.
So this is tribal ordinance in Title 10. It specifies the amounts that, different things are, so whatever.
Oh, I see there. I see what you're saying now, because for our background checks, it's a certain amount. For other tribal background checks, it may be more or less.
Yeah.
Yeah. Attorney General, this is a legal question. It's not within the reading or the writing of this particular.
Okay, one more question.
Okay.
If you don't mind. Was the election board, were they notified that there was going to be a tribal ordinance change?
I don't know that the election board, Assistant Chief, you know the answer to that?
I don't
Yeah.
think that they were not informed meeting or anything.
Okay, if we don't know, then the answer is probably not. And it's become a source of irritation for me as a council representative, that we make an ordinance change, and that board, that commission, that body is not even notified that there's going to be a change in the way they do their business.
We will say this, and an answer to that. There was a council representative seated on this body of council that would not have been seated had the background checks been expounded, because they didn't fit the constitutional provisions, because they didn't expound their background checks and they were limited. So the election board, even though I agree with you as far as informing them of this, they are not the lawmakers of this nation, but the lawmakers of this nation sits before me right now, and that's you and each band that's represented here tonight.
No, but I mean,
And it comes in conformity with McGirt. Our whole eastern Oklahoma is now reservation, including other reservations that have been expanded since then. And we do have candidates from time to time that live within these particular jurisdictions, and it's not covered in their tribal courts at this time for us to do a background check within their tribal court system if they've had to appear in those tribal courts. So it just gets, it's basically something that has not been adjusted to the new laws as far as when McGirt's come out in the jurisdictions and the expansion of tribal courts during this period of time of McGirt.
Thanks, sir.
Any other, Representative Shaw?
On that same bill, that Representative Death is talking about, it also says effective date. It's not always, you put down here effective immediately upon proper approval by the Seminole Nation General Council. It's not what do you call it, in stone until that seal goes on there to see you sign it. So I don't know why you're making it like, now.
Well, usually what happens is that it becomes effective at the approval of the general council, and then there's what we call a certification of the resolutions, which usually take place within a day to 3 days after the council passes either an ordinance change or a resolution.
The reason I'm bringing that up is because it's never been there, we've never done that. Now all of a sudden we're gonna do this because we want to go into complaints and stuff. All right, if we go into complaints, we've already passed this, then we can't complain because, no, you're breaking the law now. That's what you'll say. So I don't think that's right. Not upon that passage. If it's gonna pass, then it passes, but the thing is, it's not upon exact 30 minutes, if we pass it 30 minutes from now, it doesn't go into effect 31 minutes from now. Instead, right now, it's got to have your signature and the seal on it before it's valid. And our Attorney General should know this.
If this passes,
If she wrote this, she should have been able to tell you, no, I can't do this, can't put that effective immediately upon passage by the council. Because until that seal is affixed to it, and your signature is attested to it by a notary, then it's just a piece of paper.
it's actually attested by the council secretary on all resolutions and ordinances by tribal law. But obviously, if this was to pass tonight, would have to be concerned about it till, people start filing for candidacy for offices. So that's several months away still.
It looks like you're trying to make the laws for yourself.
Yeah, it's for everybody that runs for office, if it was to pass. Representative Yesleth?
Can I hear from the AG's opinion on this?
On the effective date, I believe every ordinance change that we've drafted in the last 4 years has had this language in it. I believe that if I had drafted it the other way, this body would say, we are the legislative body, and when we vote, that's when the ordinance change goes into effect. I also believe that the chief or the assistant chief could refuse to sign an ordinance, and then there would be a matter that would have to go to court, and then the ordinance would not be in effect. So I'm in a catch-22 here, but I believe the way it's written is correct.
If the general council passes something, this chief will sign it. Then you may have somebody sitting on this council that is not really truly constitutional. It's a violation of the Constitution. This would be actually in conformity with the Constitution of the Seminole Nation, and we know that it's already happened. And for this council not to consider a change because of laws, that's your option. Did I have someone before Representative McCoy? I think I called on Representative Shaw. Representative McCoy?
Let's see. Okay. Just a question off of Representative Yesleth's statement about the AG. Is the AG still, is her contract still valid, or has it expired, her RFP?
Excuse me?
the AG's RFP that she signed, is that still in effect or has it expired? Because if it's expired, I don't think we've extended it out.
That's a whole nother matter. There's a motion and a second on the floor, but we do know that tribal code is not what we call superseded by a resolution. Tribal code, and there's precedence to that too. When Corwin Dunleavy was the Attorney General, and we changed it from 1 year to 3 years. It continued on from that day of council passage. So, and I do have those resolutions pulled if you want to see those things as well. But we're going back to the original question. Representative Petit.
Okay, and my question is regarding the election board, since we brought them up. In September, we added 3 new members to this, but we already had the Fasucci's had Tim Hooper was still serving on the board. So does that make 4? Are we already exceeding, or do we?
I could go back to the minutes where we discussed this very question that you're bringing up, and if I remember or recall right, you were the one that brought it up. We do have a General Counsel Secretary. Do we have a resignation from Representative Hooper from the election board?
Yes.
Okay, so we had one prior to this.
Sure we did, yes.
Yes.
Approved. Okay, well, that was just my question.
And
I just wanted to make sure.
And we've already discussed that, Representative Petit.
Okay, but I don't think we had one in writing back when we discussed it in September, so anyway, if we had one, that's okay, I don't have a problem with it.
Okay, Representative Lonnie?
With all these background checks, and probably what it'll cost too, but doesn't OSBI, they do a thorough investigation on that? On the background checks, do you know, or what?
See if I can take the floor.
It was hard for me to hear your question, I'm sorry.
Okay, with the background checks, with all these background checks, okay, through, say, for example, that somebody's out of state or whatever, they're not gonna, doesn't OSBI, do they do a full investigation on the background check, or do they? They have to do it, or?
Not necessarily with tribal courts. Some tribal courts, just like with say with the, what we call the Turnpike Authority, we don't turn our tags into them so that when somebody goes through, they can run that tag. A lot of tribes don't report to the OSBI what takes place in their tribal courts. Some do, some don't.
Because I know some of these municipal courts, all they can actually really report is like misdemeanors and stuff. And it takes a lot more time than probably 4 or 5 days or more. And sometimes if you would even identify yourself, say for example, hey, we're the Seminole Nation, they're not gonna even care.
I don't know, but Representative Lonnie, you're sure answered for a lot of unknowns.
Because I have background family that's in tribal lawyers and lawyers in my family, so I had to look over some of this stuff. So
I don't know.
So that's why
the election board is
Can I
here.
talk right now, or are you gonna talk? I'm talking right now, please. It's kind of rude that when somebody's got the floor here, you undermine them right here, right now.
Well, why don't you stand up, which is in the code to stand up when you have the floor.
Might be a little bit taller than you, but I will. So, are you gonna answer my question or what?
You're asking what
Well, who was the one that came out and whose idea was this to put this down? I mean, who was the one that went to the AG and put this in this form? Who was the one that worked on it? I'm just curious. Just want to know.
Probably if I worked on it, you wouldn't have any questions about it.
Why is it such a need so fast to call a special call meeting and waste money without an explanation?
Well, the special call meeting isn't for the first two provisions that's on the agenda tonight, but basically, the special call meeting is for this tribal resolution 2025-01.
Okay.
Yeah.
All right, simple, thank you. We'll go.
Any other questions? We're on the TO 2025-01. If there's no other questions, then we're going to go to the roll call. This is Representative Petit. Yeah, TO 2025-01.
Okay, I thought you said 11, so I'm correct. Okay.
No, I said 01. It's the first meeting of this year, so it can't be anything but that.
Yeah, we're at 15 minutes.
All right, we will vote accordingly, and I will stress to the council, we have had a council representative sit on this governing body that by constitutional provision was not supposed to be sitting here. That's why expansion of background checks is necessary in this day and time that we live in with the tribal courts throughout Indian country. All right. Secretary, call the roll.
Leetta Sampson. Here. Anthony Conley.
Yes.
John Narcovic.
Yes.
Rena Tiger. Nancy Fixico.
Yes.
Leon Petit.
No.
David Narcovic.
No.
Joseph Billy.
No.
Dolores Harjo. Karen Fulbright.
Yes.
Ann Borba.
Yes.
Stephanie Lambert.
Yes.
Sina Yesley.
Yes.
Lottie Cootie.
No.
Marilyn Moore.
No.
Ensign Lena.
No.
Richmond Larney.
No.
Tiffany Thunder.
No.
Wayne Shaw.
No.
Catherine McCoy.
No.
Charlie Hill.
No.
Danita Harjo.
No.
Willis Dethridge.
Yes.
I have 9 yeses, 13 noes, 0 abstain.
With a count of 9 yes, 13 noes, and 0 abstentions, I declare TO 2025-01 to have failed. TO 2025-02.
Chair, I'm sorry, what was that count again?
9, 13, 0.
TO 2025-02, a tribal ordinance of the Seminole Nation of Oklahoma, amending Chapter 9 of Title 16 of the Seminole Nation Code of Laws. What does the council desire to do?
I'll make that motion.
Motion to approve, is there a second?
Second.
Second by Representative Dethridge. This is TO 2025-02, the tribal ordinance of the Seminole Nation of Oklahoma, amending Chapter 9 of Title 16 of the Seminole Nation Code of Laws. Representative Shaw.
Reading this, and it says, it states in there that employees can talk among themselves. They only can go to you and the HR. They got human rights too. After 5 o'clock, they're no longer employees, and they should be able to at least come to your, they got, why we got representatives for each band. They should be able to talk to their band, they should be able, and Lewis, you've been around long enough to know that we brought those people to this floor many, many times. And as a quasi judicial group, we have the last say on that, not the council, not you, not the HR. So, you're taking their rights away from them by saying that they can't go to their band meetings, they can't talk about nothing. In other words, unless I say so, you can't say nothing. And so I'm gonna have to, beg to differ with you and tell you that our band would look at that human rights side of it and would say no on it.
Representative Yetzeth.
I'd like to ask the AG what was the reasoning or what was brought to her in order to prepare this?
The language of the bill was brought to me in substantially the same form it is. All the AG's office did was cross-check it with the other laws and ensure that it was in compliance with the other laws. Otherwise, it's up to this legislative body to pass this or not pass it. If if there's a specific concern, I don't truly know which provision, Representative Shaw was talking about, but, I'm not gonna say I'm perfect and I thought everything through. I just tried to compare it with the other laws we have and ensure that it was in compliance.
Yes, Representative Lonnie?
This is a question for the AG. All the ones like on page 4 right here, that said like, for example, 6A, those crossed out, those are all the ones that are no longer gonna be in this ordinance?
No, that's just because the numbering was incorrect, and so when we went through to correct it, we corrected, it should have been 6, 7, 8, 9, 10, and not ABC. The formatting was just incorrect, so we corrected it.
Okay, thank you very much.
Any other questions?
Chair?
Yes, Representative Fulbright.
Well, I think this is long overdue on some of this stuff. I know the employees go through a hard time sometimes. When we have certain council reps that go up to the complex and, I'll put it like this, throw their weight around, you know, and feel like they can use any kind of language with the employees and they're just not to say anything. I think this kind of puts a little bit of limits on what can be done up there. I mean, to me, it's just common sense. When you go somewhere, you should know how to act. That's what I was taught growing up. When you go out, you better know how to act when you go somewhere that reflects who you are. And a lot of this is including on council, not just the employees. I mean, to me, it adds a little bit of protection for them. And even like on the drug testing and stuff, I mean, does that mean we should all go through drug testing? Probably, not just the employees. You're getting paid through the tribe. So, I mean, I support this bill. I mean, I'm sure it won't pass because it'll affect how you act when you go to the complex, but that's just me.
Anyone else? Representative Petit, then Representative McCoy.
In regards to what you were saying about the drug testing and stuff like that, today in the environment we live in, we have so many people that are on medical marijuana, and that's going to be a drug testing on their part. And I've noticed that, you know, we've had problems getting employees because they are under the influence when blood tested because of that. Is that going to be a problem with this language in this resolution? Or change?
Chair.
Are you asking a legal thought on that, Representative?
I would ask, yeah, somebody just needs to tell me, because that's something.
Attorney General? Attorney General?
What was the specific question about drug testing?
Well, under the section B here, I haven't looked through the numbers to see which one it is.
Right now, it says, you know, if we run a drug test on a candidate for employment at the Seminole Nation, right now, if they test for THC, you know, they're not, even if they have a state license for medical marijuana, they can't be employed
The nation is
at this time.
a drug-free workplace to comply with federal law. So if we're talking about line 165, that is currently the nation's policy, I believe. That's nothing new, it's just been added to this section.
Okay, so what you're saying now is if a person is currently under medical marijuana, if they were to try to go work for the nation, then they would be not eligible because of the language in this ordinance?
They're not eligible now.
They're not eligible.
And that's the same language you said, that it's just in a different place. We've lost some pretty, what I would say, great candidates that pulled on my heart.
That's understandable, like I said, today's environment, since that's such a big deal in Oklahoma now, concerned that I have. Also we discriminate against, we'll make it harder on those people who want to try to bring forward, you know, and they may not be in good voice, and this gives you an out, I guess, is the way it is. But that was just a concern I had when reading that. I thought, well, you know, I know a lot of employers have a hard time getting employees because it's violent in Oklahoma now. Are you?
That's true as well. Anyone else? Representative Lena?
I just wanted to expound on this lady's comments a while ago about protecting the employees. You know, I told y'all before that we get phone calls every day from your band members. And they call us every day asking us to step up and just talk to them. But if you want to point the fingers, what we're saying is the fingers need to be on this administration. The HR and this administration, they're the one that's in charge of all this. Regardless how you look at it, this is a business. And if we don't run like a business, we're going to fail. And we see these ones getting away with everything. We will see some of our leaders getting away with everything, but y'all turn the other way. That's not right. And you've been sitting in that seat for a long time. And where have we gone? Nowhere. And you've been a part of it. Before you start pointing fingers, y'all need to examine yourself.
Point of order.
That's it. Of course. Yes.
And this law will actually affect tribal leaders as well, if it was to pass. Representative Lambert?
This is basically just copying over Title 11 to the council members, is that right? Yes. Yeah. So
certain parts of it.
Yeah, pretty much. The only, I mean, I think that we do need to have some type of rules, but I thought we were already supposed to adhere to most of these rules of conduct as well. I thought they were already in a title, like, somewhere else.
I don't think they're as strengthened as they can be, the strength of them.
One of the things that I'd like to see in the future is like a limit, like a dollar limit on some of these things, because some of them, even though they're just like the employees, they look, it looks like it could restrict us from campaigning, like the raising money or accepting money for political reasons and that kind of stuff as council members. It looks like it could keep us from campaigning. And what is the amount? I mean, would this be a bribe? What is our dollar amount on a bribe, and what can we accept as, because if we pass this, would this be considered a bribe for us to pass this? So, I mean, I'd like to see a dollar amount. I think even Mr. Petit and I had visited before about when the gentleman came and offered us a movie about accepting bribes that way as well. The Department of Interior, I believe, says $20 is the amount of a bribe, but we need to set an amount on what that is, because I can give you a gift from Walmart and it costs $15 and somebody might consider that a bribe. I think we really do need to have, or I could take you out to dinner at the Flame, and that could be considered a bribe, because the difference in a $15 gift or a $50 gift, so I mean, I think we really do need to set a limit there, so that way we know, because we all perceive a bribe as something different.
Yeah, not necessarily anything that's done for somebody is within that category, obviously.
Yeah. And I think that, and we've seen it happen over and over again. We've seen construction companies go down for bribing people and taking people to fancy. I think that there needs to be a dollar limit set on it in the future. And there's a couple of them that I think could be dropped off, but for the most part, I think strengthening it is a good deal, but I think that this right here is just a little bit, I think that some of it's too much and some of it's not enough.
Thank you for your comments. Anyone else? Representative Shaw?
The portion I was talking about a while ago is on page 5, right there at the bottom. It says taking employee personnel matters to any public forum, including general council meetings. You're taking that right away from meeting with your council reps. Not only are you taking that right away from, but if I'm sitting in my house and I talk about somebody did this, then that's public forum also in my house, my own home. So you're invading my privacy by, passing this law. I saw this, you know, but I know we're speaking on this, but I'm still puzzled. I need to know, are we operating within the law right now with the AG? That was one of the questions that was asked earlier, and it hasn't been answered. Because I saw no paperwork where it said, where or what do you call it, agreement, her contract surpasses any date with her name on it. So therefore, are we operating within the law? Because we have a law that says that you cannot operate without an AG. And nobody said if she is supposed to be there or not there. If she's supposed to be there, then it needs to be voted on by this council and by name. And the other thing is, if she's not supposed to be there, then we're operating illegally, and we have to change that law or suspend that law tonight in order to do any complaints or any business at all. That's the reason I'm trying to get in early before.
Order, I think we're talking about TO 2502.
Well, this is Title 16 here. You're on title.
Where are we going?
I still got full.
But Representative Shaw, you are speaking about Title 2 when we're on a tribal ordinance possible amendment for Title 16. So maybe under...
Do we have a contract with this attorney right now?
We have tribal law that extended...
Not tribal law. Do we have a contract?
We have a tribal ordinance that supervents those types of things, and we have a precedent when Quillen Dunleavy was 1 year at a time, every March we would have, a vote of attorney generals. And at that time, if I remember right, Tallahassee and Tom Palmer at the time, brought this ordinance change that expanded it to 3 years, and therefore it continued on for another 2 years, which would make 3 years.
Well, every time I say precedence is already said, you say, no, it ain't. So now, I want it in black and white.
I thought the council secretary...
Do we have a contract with Mr. DeVoe's name on it? Do we have a valid contract that she is to be our AG now, tonight?
We have tribal law that says that it's extended to 4 years, Representative Shaw.
No, we did not extend her for 4 years. We extended an AG to come in at the end of this 4 years. We did not say she can stay here till then.
That's an incorrect interpretation of what was passed on the council floor. It's a matter of fact, sir. We're going on to the original motion.
You still did not give me an answer, and you never give me an answer.
We're not even on this subject matter, sir.
I'm wondering, are we legal? That's what I'm asking.
Yeah, we're legal.
How? Show me that contract.
Look under the last ordinance this council passed.
That ordinance does not mention Ms. DeVoe in any way.
The ordinance represents the title of the AG, and it was passed at the time she was the AG. Now,
but it does not say...
No, sir, you're just creating confusion. We're moving on to the original motion, and that's...
You didn't give me an answer, sir.
You're out of order because you're not even in the right perspective, sir.
I'm not out of order because I'm trying to find out if we're legal or not. I can't take your...
Whether we have an AG at this meeting or not, we went 3.5 years or so, however long in the last term without an approved AG,
Approve that one.
Yeah, we didn't have an AG for 3.5 years the last term.
You know what?
And nobody brought it up, except, well, certain ones never brought it up. Certainly not you, Representative Shaw. We're moving on. We have a motion and a second on the floor.
Call for question.
We have a, no, it's out of order. Representative McCoy, and then we're moving on to the vote.
So to answer your question, it's TR 2022-13, and it does say that she's the Attorney General for 3 years, commencing on January 29th of 2022 and expiring on January 29th of 2025,
Thank you.
which is already passed.
Can you answer a yes or no question? Does tribal code, not circumvent, but does it precede, does the Constitution precede everything?
Yeah,
Does tribal code precede resolution?
yep.
Okay, folks, y'all's not new. Come on.
Wait,
Right.
if you think she's not supposed to be the AG here on record, just don't get your check.
I don't get one anyway.
All right, we're going on. We got a motion and a second, and this is TO 2025-02. Secretary, call the roll.
Leetta Sampson. No. Anthony Conley. No. John Narcome.
Yes. Yes.
Anastasia Pittman.
No. Oh, yes.
Nancy Fixico votes yes. Leon Petit.
No.
David Narcome.
No.
Joseph Billy.
No.
Dolores Harjo.
No.
Karen Fulbright.
Yes.
Ann Borba.
Yes.
Stephanie Lambert.
No.
Sina Yeslett.
No.
Lottie Cootie.
No.
Marilyn Moore.
No.
Ensign Lena.
No.
Richmond Larney.
No.
Tiffany Thunder.
No.
Gwen Shaw.
No.
Catherine McCoy.
No.
Charlie Hill.
No.
Danita Harjo.
No.
Willis Dethridge.
No.
I have 4 yeses, 19 noes, 0 abstain.
4 yes, 19 noes, and 0 abstentions. I consider that to have failed. It's proclaimed that it has failed. TO 2025-02. We have TR 2025-01, a tribal resolution authorizing the execution of lease agreements under authority of the Section 105L of the Indian Self-Determination and Education Assistance Act, ISDEAA, with the Secretary of the U.S. Department of Interior for certain facilities used by the tribe in administration and delivery of services under the ISDEAA law enforcement in courts, contracts between the Seminole Nation and the Department of Interior. I entertain a motion to that effect.
I'll make a motion.
Motion made, second? Second by is that you, Representative Larney? Yes, sir. Second by Representative Larney. Discussion? Representative Larney?
Yes, who do I make? I'd like to make a friendly amendment to designate which account will these lease or rent funds go into. Example, like for maintenance or the funds to maintain the building. I just don't want it going into like, general fund or something like that. I mean, I want it to be in a separate account for like, maybe say, for example, we do lease and rent these buildings. That way, it can self-sufficient, maintain those buildings or something like that.
Exactly. The language can be amended to, create a certain account. And of course, any appropriations from that account would come to this council. It should be used to maintain those facilities. Maybe occasionally, if the council desired, it could be used to supplement a light horse or tribal courts for whatever reasons. They may come up an emergency situation. They would need assistance in that, and that would be a council decision as well. So, okay, there's a friendly amendment to create a specific account for this particular leases, and I will share with you that this is the first of many that will come. All of our 638 leases, and of course we have challenges, since the since the change of administrations in the Capitol. But this has already had been approved. Hopefully, all of it will come down, as far as lease and grant monies. We believe that it will. This was needed to be able to draw down these funds. We had talked about it in December, and, kind of wish we would have done it back in December. We would have those funds drawn down already. But a very good point, Representative Larney. Is that friendly amendment accepted by the original motion? Okay, we got a yes here. And you seconded it. So that's accepted at this time. And basically, it's going into a specific account, these particular lease funds. The way we look at it in the very near future, we're on 638 programs, and as we get established in 477, we're going to be able to have lease funds for those spaces as well, for an expanded area outside of 638. So it could actually possibly bring anywhere from 1.5 to 1.8 conservative $1 million into the nation. Representative Shaw, then Representative Dethridge.
I know it's not the courts and stuff, but I do know, talking about leases, how come we haven't renewed the lease with IHS on that building over there, and hasn't been renewed for several years? And according to this, you've known about this since '23, why is this so important tonight?
It was in the process of application, and I think it was the first of last year. Last year, maybe late November, right before the quarterly meeting, that we wasn't able to put it on the agenda officially. We talked about it at the quarterly meeting, actually. So you put in your application. It's like any other thing, SSBCI or anything. An application is approved to submit for that, and then sometimes it don't come till later. So we're fortunate to be able to do this. It's been available since 1996, and very few tribes actually utilize this particular section within the interior. And it's going to be a great reoccurring funds as we get established in it. And appreciate Representative Maloney putting it in a specific account for these specific purposes. As we expand, we might have to expand that as well, as far as what the uses are per each lease, so that it goes back to help support those particular areas where it should be. Well, I'm not sure exactly what you're talking about, IHS. The leases of the Division of Commerce?
Well, that's supposed to be under CENDOF. CENDOF hasn't been able to do anything with it.
Division of Commerce?
Huh?
They got an existing lease right now.
They got their old lease.
Yeah, that's an existing.
You renew your leases yearly.
No, usually, and I know they're working on a lease right now, and I understand it's for 20 years, and usually it's for a long period of time. It's usually not just a year at a time.
There are increments, like for each year to go up. We haven't seen any increases. And as a matter of fact, we don't know if we're getting money coming here because we don't get reports on those.
Well, I'm not Division of Commerce, so, but you could ask that question at the quarterly meeting. Let's move on. TR 2025-01. Representative Dethridge.
Thank you, sir. Just to expound upon what Representative Larney made mention of trial courts and police, Whitehorse Police Department, that those are going to be earmarked, and all future, you said something to the effect that all other future agreements that we have with this organization here, that money will be earmarked as well, where we know how much that money is.
Oh, definitely. It'll be a part of, it'll be,
I just didn't want the additional money to get lost in somebody else's.
No, it's not going to general fund. Obviously, that's not where it would go anyway. But you want it to go back for the purposes that it's designed to do. Okay, with those friendly amendments, TR 2025-01, with those friendly amendments. Council Secretary, call the roll.
Deanna Sampson. No. Anthony Conley. No. John Narkemy,
Yes.
Anastasia Pittman,
No.
Nancy Fixico,
Yes.
Leon Petit,
No.
David Narkemy,
No.
Joseph Billy,
No.
Dolores Harjo. No. Karen Fulbright. Yes. Ann Borba. Yes. Stephanie Lambert.
Yes.
Sina Yeslip.
Yes.
Lottie Cootie. Marilyn Moore. Vincent Lena.
Yes.
Richmond Army.
Yes.
Tiffany Thunder.
Yes.
Wayne Shaw.
Yes.
Catherine McCoy.
No.
Charlie Hill.
No.
Denita Harjo.
No.
Louis Dethridge.
Yes.
I have 11 yeses, 12 noes, 0 abstain. Yeah, I have 11 yeses, 12 noes, 0 abstain.
Well, we got money on the tree there, Miko. 600,000.
We'll bring it back during the quarterly meeting, because this is, I hope that you, Vance, met, you understood what you were doing, because obviously, when you have a chance to make $1.8 million over the course of the next year and a half, it's probably worse decision than the 250 jobs that was voted no on. But anyway, there we go, if that's the original count, it's wonder. I declare,
Sure.
by the count of the year 2025-01 is failed.
I don't believe it. Yeah, I do. Anyway, Chair, got a question. Are we through with the agenda other than executive session?
Yes, and I think it's a lot worse here because if they're not here, then we probably need to go into executive session. I thought it's on here.
I just want to get a little bit of an update. We were talking about this with the Trump administration, with the cuts and everything. How did that affect us that day when, I mean, as far as drawdowns, and I know it's a temporary hold, I mean, you know, it's on hold now. Can you kind of give us an update of what we're looking at?
What you're looking at when that took place with all the executive orders, Indian country across Indian country, all spectrums of the tribal nations obviously had to act fast as possibly they could. And the objective was to draw down as many funds that you could obviously allowed to, that was within your programs. We were able to accomplish most all of that. With the judge's orders that put a stop to those executive orders, we haven't had any issues at this point, you know, with drawing down other types of funds that were by regulation only can draw down so much at a time, right? Some you can draw it all down at one time, some you can't. It's just the way the rules and the regulations are. But hopefully the court standings hold up and we'll continue to operate as normal as possible. Now, we did get word today from the food distribution program they've been speaking with Jamie Hipp, who is at the national level, who definitely wants to go before senators because, you know, with some of the executive orders, the program SNAP is threatened to possibly be discontinued at the federal level, which will cause an influx of people who are not now on food distribution program to be able to have an influx of people coming into that program, which means your inventories and your allowances for that program has not increased. So the option for, you know, executive and other leaders, and then the food distribution program, along with Ms. Jamie Hipp, who carries a lot of clout in the USDA, we're going to visit with those senators to be able to try to secure, you know, additional fundings if SNAP does no longer exist in the United States. So it's very detrimental that we are able to continue this, and we will as we can. So we're very, very well tuned with what's going on. We have worked with other tribes on this matter. We have met with the organizations of all 38 tribes of the state of Oklahoma. Intertribal, of course, we have been dealing with other things, DEI, diversity, equity and inclusive, diversity, inclusive, and equity. We had to make sure that our people understood. A lot of our people were, and then even some people on the Hill in D.C. was trying to include Indian country in that, and we had to make it very clear that you're not releasing funds through the budget process to a race of people. You're releasing it to political status that has treaties, that has a stance with the federal government, with executive orders and arrangements and contracts, and it's much different. So don't tote us in that type of ideology, because that's not the way that it is in this country. So right now we're going to keep on going through, and yeah, it's council willing at this time to go into executive session. And you know what? I don't know if it really needs to be executive session with the Light Horse. I don't think the complaints are going to be addressed today. There are a couple of written complaints because Light Horse has also looked at those complaints as well. But Coker, unless Coker says, oh, I don't know that it should be an executive session. I mean, it can be, I suppose. I think they wanted it to be an executive session because it deals with another government, but it's up to the council. Representative Lambert?
I make a motion to go into executive session.
There's a motion to go in a second by Representative Yesleth. So there's a motion and a second to go into executive session. And gallery, what that means is if we're able to turn the screens off on the outside entry, and then you set at the very end over to the far west, then I think we'll be okay. And do not go up to the door and